Hi everyone, my name is Ali Mazurik. I'm with Northern Waters Land Trust and I'd like to welcome you to this webinar on cabin succession planning for your valuable lake property. I'm joining you today from Grand Rapids, Minnesota. Northern Waters Land Trust is based in Walker, and if you're familiar with the state or this part of the state at all, you know that this is lake country. This topic is particularly relevant to folks within our service area because many of those people have either recreational property or property, whether it's part or full-time residence, on a lakeshore. And we know that the process of planning for the transfer of that property to your successors is quite complicated. We wanted to provide some content to make that process a little bit easier. And so thanks for tuning in to this webinar today. We'll get into it. So we'll start with an overview of the goals for the webinar, and I'll also provide an introduction to Northern Waters Land Trust as an organization. We are extremely lucky to be joined today by two experts in their fields. We have Andy Biebl, a retired certified public accountant who will be speaking to us about tax barriers to transferring property to heirs. And then Laura Hanson will speak to the same topic, but from more of a legal perspective. Our mission here at Northern Waters Land Trust is preserving land to protect water. So land protection will be kind of an underlying focus to today's conversation about property transfers. And I'll be jumping back on after Andy and Laura's portion of the presentation to discuss land protection options and how they might play into your property succession planning as well. Before we get too far into it, just a brief disclaimer that we are not providing legal or tax advice. This webinar is for educational purposes only and designed solely to provide an overview of alternatives for you to consider and consult with your professional advisors. With that, we do hope that during our time today, we can help you identify some alternatives and strategies for transferring valuable lake or recreational properties to heirs, while also highlighting some charitable strategies that might benefit you in that process, while also furthering the mission of Northern Waters Land Trust. Again, my name is Ali. I'm the Grants Manager and Water Conservation Specialist at Northern Waters Land Trust, and I'll provide a little bit of background on our organization and the work that we do in North Central Minnesota before handing it off to our presenters for their portion of the webinar. So a land trust, by definition, is a nonprofit organization that works to conserve or protect land for various purposes, such as preserving wildlife habitat, ensuring public access or recreational access, or like in our case, safeguarding water quality. As I mentioned, our mission at Northern Waters Land Trust is preserving land to protect water. So we work within priority watersheds to protect undeveloped lands in order to protect water quality in Minnesota's north and north central watersheds. We take a watershed-based approach to our conservation efforts with a goal of protecting 75% of land within a given watershed. And the reason for this is because fisheries biologists have studied the impacts of land use changes on water quality and determined that if we can protect 75% of undeveloped forested lands within a watershed, the rivers and lakes that comprise that watershed are going to be more resilient to climate change, land use changes like development and conversion to agriculture, as well as other environmental stressors. So that 75% protection goal is what guides our conservation strategy. We are a registered 501c3 nonprofit based out of Walker, Minnesota, and we are accredited through the Land Trust Accreditation Commission. The map on the left here shows land use changes in the state of Minnesota over the last 175 years. And that gray region on the western and southern portions of the state indicates land that was formerly prairie and has since been converted to agriculture. And then that black band that's running somewhat diagonally across the state between the gray and green areas that is land that was originally forested and has since been converted as well. The map on the right shows Northern Waters Land Trust's priority watersheds for protection. So this side-by-side comparison is pretty impactful, I think, visually. Reason being, it's very clear that the priority watersheds and kind of our service area are located in a region that still has relatively intact forests and therefore still relatively pristine levels of water quality as well. And so it's no wonder that people choose to recreate in this portion of the state. Another kind of takeaway from this side-by-side comparison is you can really see that Northern Waters is uniquely situated at kind of this boundary line between converted and unconverted lands. And so we have, just based on our location, this unique opportunity to really proactively preserve our remaining forested lands. And we know that this is not only effective, but also the most efficient way to protect and safeguard water quality in a region that is very much famous for our lakes and rivers. Our land protection efforts fall within three main categories. So we can work with landowners to facilitate land sales or donations of land for permanent protection. We can also work with landowners who are interested in placing conservation easements on their property. And so in that way, they're looking to protect their property, but still maintain ownership and use of that property. And then we also work to educate community members within our service area about the various land protection options available to them, as well as the importance of understanding the impacts of land use changes on our lakes and wildlife. We've received $38 million in grant funding for our land protection efforts through the Outdoor Heritage Funds since 2014. And with those funds, we've been able to protect over 25,000 acres of land and over 60 miles of shoreline. One of our recent flagship projects is the Minnesota Heritage Forest, where we partnered with the Conservation Fund to acquire and convey almost 8,200 acres of forested lands to 9 counties across our region for permanent protection and also public recreational access. Another project we recently completed was in partnership with the Minnesota Land Trust and the Minnesota Department of Natural Resources to protect 450 acres of land previously owned by 3M as a wildlife management area. And you can read more about these conservation projects at our website or in the Star Tribune archives. If you're in Minnesota, know someone from Minnesota, have been to Minnesota, you know how much we love our lakes and going up north or to the cabin any chance we can get. So it's a common question from many of our followers: how do you plan for the succession of your prized family property so that it's as smooth and successful and pain-free as possible? Andy Biebl will walk us through various tax considerations related to transferring your property to future heirs. And then we'll have Laura Hanson come on and weigh in from a legal perspective on how to best plan for successful long-term family ownership.
Hello, Andy. Nice to see you again.
Hello, Laura. Good to be here.
Yes. So it's spring in Lake Country and the ice is out, the docks are in, and my phone is ringing. So I've had a number of people calling me, asking me about their lake property and the future of their lake property for the family.
And I bet that means something like perhaps the cabin into an LLC.
That seems to be coming up. The idea is out there. And so I am having people call me on a regular basis to ask about that. And I've worked with a number of families through that. Got a few done this winter and I have a few new ones to work on. So it's exciting.
Well, then if that's a popular issue these days, then we've got some good advice on how these work generically and how we can help people understand some of the alternatives before they get to their professional advisor.
That's right.
Yeah.
Well, hello again. I'm Andy Biebl, and my role in this program is to chat about the tax barriers that potentially can be there when we're looking at transferring that cabin to our heirs. So we'll address some of the potentials of tax consequences and hopefully explain that perhaps it's not as fearsome as you might have heard. So when we talk about moving a cabin to our heirs, we've given this a lot of thought as to the alternatives there, and after great deliberation, we've concluded that you're either going to give it or you're going to sell it. Now I know this is profound, but if you reflect on it, moving that cabin typically to the next generation is going to happen in one or two ways. We will move it to them without consideration, or we will sell it perhaps to one of the children that might be interested. So there are tax barriers that can come into play on either of those alternatives. And we'll start with what is most common, and that is simply giving it to our heirs. This is going to our kids, and we're not going to charge them. We wanted them to enjoy that cabin that we've enjoyed for so long. And the most common way that that occurs is to simply pass it on at death. Now, that could be through a will, through a trust, number of vehicles, but we own it. We, the parents, the cabin owners, own it through our death, and then it moves to the next generation. The estate tax is what potentially could come into play. But the good news is, for this year, 2025, when a death occurs, there's a $14 million exemption from assets passing to the heirs. That's an exemption per decedent. And so a husband and wife together, eventually passing the cabin on to the heirs, have $28 million worth of assets they can move without an estate tax. So I think we'd quickly conclude that most of us are far beneath that exemption, and we don't have a concern there. Now, a point to recall is this is a 2025 limit. The numbers have been moving up with slight indexing or inflation adjustments each year. We have a pending tax bill in 2025 that could change the system. So keep that in mind if you're viewing this after 2025. Minnesota, on the other hand, has a much lower threshold. We're one of the few states with an estate tax. The threshold there is $3 million. And again, that's per decedent. So a husband and wife together can pass $6 million of assets. And be careful of that. You might say, well, husband and wife together, we're worth $5 million. We're in good shape. You really do need to work with tax advisors and make sure that your assets are organized in a way that each exemption is utilized. Because if you're north of 3 million, you will need, with a husband and wife, to do artful planning with your assets, dividing in separate names, for example, to utilize those exemptions. If we do get over the exemptions, be careful because the federal estate tax is significant. It's a 40% flat rate, but again, $14 million exemption. Minnesota graduated rates, but not pretty, a range of rates from 13 to 16%. Now, what about moving it during lifetime? The parents might say, well, the cabin's going to be a hassle. There's a lot of work involved, spring and fall. Let's just move it to the kids today. That would be a gift, not a testamentary or estate types of transfer. But interestingly, it's the same system. The federal system says we don't care whether you transfer during your lifetime or you wait to pass it at death. You have one $14 million exemption. So in that sense of the tax barrier, these assets can move during lifetime in the same way. If I move $1 million cabin to my kids during my lifetime, I've used 1 million of my $14 million exemption. When death occurs, I'm now $13 million remaining. Minnesota has no gift tax, so we don't concern ourselves at all with that. But there's another problem, and that is that when we make a gift, we are moving that cabin at its historical tax cost. So in a simple example, let's say that I put in $300,000 of original cost and improvements to my cabin. So if I sold it, $300,000 is my point of reference for determining my tax gain. If I make a gift of that cabin during my lifetime, that $300,000 number carries over to my kids. And if the cabin is worth, for example, $800,000 and they sell it, they would face that income tax in the same manner as I would. However, if I pass it to my children on my estate and it's worth, again, for example, $800,000, it gets a new value for tax purposes of $800,000. We call it a step up in basis. And if the kids then sell for $800,000, there's no tax. So that leads to the point about the timing of a tax cost of sale. If we're going to sell it, obviously the income tax is now the barrier, not the estate or gift system. But when is the question? So if it's sold after the parents pass it through their estate, they move it by estate to the kids, and one of the kids says to the others, I'll buy it from the estate or I'll buy it from the other heirs. It's received that step up in basis, and there's no tax as a result of that rule. So if there is going to be a consideration paid, for example, by one child to acquire that cabin, the smart thing from a tax standpoint is to execute that after death. Because if it happens during lifetime, we move the cabin, for example, parents sell it to child number two, because that's the child that wants to buy it from the parents. There would be that capital gain, would be the excess of the sale price over the accumulated cost. So in my earlier example, $800,000 value versus a $300,000 cost. The capital gain rates vary. They're graduated based on the total income that's reported in the seller's tax return that year. The rates range, as you can see, from 0% if the income is very, very low, all the way up to 23.8%. But a good middle of the road number is in that 15, maybe to 18% range is where we see most of these gains fall. Minnesota does not have any special rates for capital gains. It's typical ordinary rates based on the size of the income, and typically a gain transaction would be in that 7 to 10% range. So here's an example of how this might look. Going back to our illustration, we are selling the cabin during our lifetime to child number two. The other kids are not interested. Child number two is the active user, says to mom and dad, let me buy the cabin from you today. Mom and dad are ready to leave. The work is getting to be too much. And so we sell it at market value, perhaps out of fairness to the other kids, $800,000. So mom and dad would receive that payment. And then we'd have to dig back, find their accumulated tax cost. And we'll assume here maybe they paid $200,000 for the cabin originally, made some improvements over the years. Their accumulated tax cost $300,000. So obviously a gain of $500,000. For federal purposes, we'll assume that blended rate of 18%, 90,000 of tax. For Minnesota purposes, we'll assume about an average rate of 9%, 45,000 of tax. So 135,000 of tax, not a small number, but recognize $800,000 of cash flow to mom and dad from that purchasing child to help them with the tax cost and to provide some dollars for maybe that apartment they're moving to or the senior living facility they're moving to. So after tax, they've got $665,000. It's not a small number of tax, but again, it's not an insurmountable barrier. But if we were planning that sale, and if mom and dad want to wait for that sale to occur after death, it can be done at zero tax cost, buying it after it has stepped up in basis. So let's assume that we are going to sell and we're going to face a tax on the transaction. Maybe mom and dad say, well, I need those dollars from the cabin to help with the next stage of living in life. There are a few techniques we can look at to maybe suppress that tax bill a little bit. One is the classic installment sale, where we don't sell it for cash in 1 year. Selling it in 1 year drives the income up, and as we might recall, those rates are graduated. So if you move up the scale on income, put all that gain into 1 year, it could be a 20% rate or even more. But if we can stretch it out over a number of years, maybe we keep that capital gain rate lower. So that's what we call an installment sale. It can be done in the family over a short period of time, 2 or 3 tax years, or it could be a 10 or 20-year contract, totally at the discretion of the sellers and the buyer, of course. Another technique, and you're hearing about that throughout this program, is a conservation easement. If mom and dad are fortunate enough to have some extra land with that cabin, and they're willing to say that that land should never be developed, they can put a conservation easement on that property and create a tax deduction. So that's going to be addressed a bit here, but also in other parts of the program. That charitable deduction could very nicely offset the larger capital gain and help minimize those tax costs. And let's look briefly then at a conservation easement and how that charitable deduction is generated. So let's assume that in addition to the cabin, there's some extra lakeshore, 200 feet of lakeshore, very capable of having another cabin or two built on it, has a lot of market value because of, again, the desirability of raw land, bare land on a quality lake. So we'll assume, just for discussion purposes, it's worth $450,000. Let's assume then that mom and dad decide to put a conservation easement on it. The easement would say that land will never be developed. It'll stay bare in perpetuity for a conservation purpose. That's going to reduce the value to, we'll assume again, the appraisal says, well, if it's just bare land, you can walk on it and enjoy it, but can't build a cabin on it. Now it's only worth $150,000. That's a $300,000 reduction in value from that conservation easement. And that becomes a charitable deduction if you simply do it and place it without any consideration. Or on the other hand, you could be paid for that under some of the programs that are available and receive $300,000. But again, as a tax play, we might put the conservation easement on and reduce that capital gain that otherwise is occurring. So let's talk about this idea of cabins and moving them to the next generation, and why people like myself as a CPA tax advisor and Laura as an attorney see such difficulty with these cabins and why they are a bit unusual. Now, if we're going to pass it on, we could pass it on through Minnesota intestacy laws. If we don't have a will, the state is going to define by relationship who receives your property. So if there's 3 kids, it's typically going to divide the property to the 3 children. But most people will use a will because they want to be a little more artful. And if they have 3 kids, for example, they might say that my assets all go to my 3 heirs equally. But and that's fine with your IRA, it's fine with your investments, it's fine with most assets. But the cabin is unusual. The cabin is something that has to be shared. It's going to be used. The goal of the family is typically keep the cabin within the family, let all the kids enjoy it. The problem with that is it ignores a lot of the realities of how that cabin is going to be used when it moves down a generation. Number one, the kids are not going to use it equally. There are different distances, they have different things going on in their lives, and we all understand that. So there's going to be unequal use inevitably. The other obvious point is the kids aren't all going to have the same capacity to help carry the overhead on that cabin. Some are going to be in good shape and the overhead is not an issue. Others are perhaps going to struggle with those real estate taxes and insurance and the fact that we need to pop $20,000 into a re-roofing and all of those types of surprises that can occur with any piece of real estate. And the other point, which often isn't thought through by the older generation, those kids are not all going to use that property the same way. They're going to have issues with getting away because of their children's activities, their ability and willingness to help with the maintenance. All of those issues are going to be there and be an impediment to just throwing it out there and hoping that the 3 kids are going to sort it out on their own. And then there's that problem of one heir that decides they want out of the deal, they want to sell, and how does that work out when all of a sudden we have the kids having to butt heads about a sale price and the terms of the sale. So again, the danger is throwing the asset out to them equally and hoping that they can sort out all those issues. And then there's the worst horror of all. We have one of those kids unexpectedly pass away, or there's a divorce, and 1/3 of that cabin, for example, goes to that worthless son-in-law. So that ought to scare you, if nothing else, into being more artful about how you move that cabin down to the next generation. So that leads us to this topic of a solution. Laura, as an attorney, is going to be helping us understand how we use an LLC or perhaps a trust to take that difficult asset and put it in a way that can make it easier for the kids to handle it, manage it, and share it in a way that doesn't create disharmony within the family. So we'll turn it over to Laura.
Okay, I'm Laura Hanson, and I'm an attorney with Breen & Person, and I work with a lot of families on the lake property, the beloved lake home, and working to pass that on to the next generation of owners. Thank you, Andy, for all that very useful information. There are a lot of tax implications to owning lake property and passing that on to the next generation, and they should always be taken into careful consideration. So what I'm going to focus on in my presentation is if a family has decided that as a group they want to own a lake property together, what's the best way to do that? So what I will cover in my presentation are what are the keys to successful long-term family ownership or multiple party ownership of a property together? What are the consequences of lack of planning? Andy covered quite a bit of that in his own presentation, and I'll touch on a few other issues. And then also my recommendation on the best way, in my opinion, to own that property together and how that might be done. So the keys to success, if you've heard my presentation before, if you've worked with me before, this is my mantra, and it has nothing to do with legal issues. The keys to success for long-term ownership of a property for a group of people, the first key is a strong commitment to own the property together. There's a very big difference between owning our own home, making all the decisions about it, paying for everything ourselves, or maybe with our spouse. Big difference between that and owning property with a group of people. So there needs to be, first and foremost, a commitment to doing that and owning it together and doing that for a long period of time. We also need strong communication skills among the group. And so we need a group of people who are willing to put in the time to communicate together, learn how to make decisions together, and do that throughout the year, not just when they're hanging out at the cabin together. And as Andy mentioned, we need a group of people willing to do the necessary work. So it's managing the cabin, managing the ownership together, as well as the work on the ground. Everything from calling the plumber to raking the leaves and making sure that dock gets out. Lastly, it's also important to keep in mind that within a family or within a group of people, people might have different financial needs. And so that needs to be taken into consideration, especially for the generation that wants to pass that cabin on to the next generation. We don't want to put people in a difficult position where they can't participate, where it's difficult for them to participate from a financial standpoint. So the best thing to do, of course, is to plan. And what I'm mostly going to present on, which a lot of you, I'm sure, have heard of, is the Family Cabin LLC. What I like about the LLC is that it allows you to tailor the agreement within the LLC for your own family, for your own property. So a plan allows you to tailor your plan, tailor that entity to your own group. The other thing it allows to do is it allows the group who are the owners to accommodate change over time and anticipate change. We might put a great agreement in place right now, but more than likely things will change 5, 10, 15 years from now. And that Family Cabin LLC, the operating agreement, allows the group to accommodate that change in the future. So what if you fail to plan? Again, Andy mentioned a lot of the downside to that. If you don't have an agreement, if you haven't talked about all the issues that need to be talked about, there's a much more potential for conflict. Another issue when we own property is that our spouses have a marital interest in that property. And so if someone gets divorced or if they pass away, we have to address that marital interest, and we might have to buy out a spouse if we haven't addressed that interest in an operating agreement. If we own property in fee with other parties, if we own it as joint tenant, or if we own it as tenants in common, if somebody passes away, then a probate will be required at that time. And so if we all own it without putting it in an entity or making some other accommodation, we might have a probate each time an owner passes away. And that's really an unnecessary cost. If a family can't get along and they own the property in fee, and they can't agree on a buyout, and we end up in a situation where we have a group of siblings, for example, who aren't talking to each other, one of them will have to bring a partition action in order to address the ownership. And that's partition action is that someone petitions the court, and basically the court orders 3 appraisals, and orders the property to be sold to a third party or for one to buy out the other. And so the group loses control of the process. They might have an outcome that is bad for the family and really undermines that legacy of the family cabin. And worst of all of that, of course, is the loss of the family relationship with siblings and other family matters, and loss of the legacy. So one option for owning a property long-term would be to put it in a trust. And I do see this from time to time. And a trust is a good way to, number one, avoid probate. And it does allow for some accommodation as to who should be allowed to use the property and who's to pay for expenses. The downside of a trust is that the way it's set up is that we typically have one trustee and then multiple beneficiaries. So we really only have one decision maker long term. That puts a lot of power in one person, and it also burdens a single person as well. A trust is set up typically by the parents who own the property, and they set it up at the time, prior to their death. And once they pass away, the terms of the trust become irrevocable. So we have a group of people who are subject to terms of a trust without the ability to change those terms. And that can lead to conflict and not a good situation for them. And as I mentioned before, the LLC accommodates change, and I'll get into that in a little bit. And a trust really does not. The other thing, bottom line, a trust does not allow is long-term, perpetual ownership of that property. Property cannot stay in trust forever. There's something called the rule against perpetuities, and eventually an asset in a trust has to be distributed out to the beneficiaries. So a trust isn't really a good long-term option if the group of people does want to own the property for a long period of time and maybe forever. So in this area, my recommendation is typically the family cabin or the family lake home LLC. And I'll get into that in more detail. So a limited liability company, typically referred to as an LLC, is a business entity, and it's created by filing articles of organization with the Secretary of State. The owners of an LLC are called the members, and their ownership is expressed as a percentage. The LLC is really a modern form of partnership. An LLC can have a perpetual existence, so it can go on forever. And so in contrast to a trust, it really is a nice option that we don't have some kind of looming deadline in which our entity, what we've set up, will have to end. The LLC can continue on forever. The LLC, as an added bonus, provides a limited liability protection for its members. So in any case in which a family cabin or a lake home might be rented out, the LLC is an excellent choice for that. The LLC is governed primarily by what's called the operating agreement. And at its heart, the operating agreement is democratic. And what I mean by that is that each member has voting rights. They're typically equal to their ownership percentage, although they don't have to be. But it's the owner members of the LLC who have the decision-making power to decide what are the terms of the operating agreement, how are we going to own this property together, and if they agree, they can change that over time. So what I really like about the LLC versus a trust is that the terms can evolve, they can grow, and they can accommodate change, as I've mentioned. And we're not dictated by terms that were set 20, 30, 40 years ago, which seemed like a good idea at the time. The terms of the operating agreement can be changed over time. So what is in this special operating agreement that I keep talking about? The operating agreement is what we typically think of as bylaws, and then the governing document. It also addresses financial interests. And in the case of a family cabin LLC, it can address use, assessments, how are we going to pay for the expenses, how are we going to make decisions. So let's get into that a little bit more. The operating agreement can state whether all the member owners have the right to use the property at the same time. I've worked with families who own a larger piece of property on a lake, and they have multiple cabins. and they've assigned cabins to families, or each family has a place where they can go, and so they can all be there together. There are other families where they divide the use up by weeks. And so it's almost functions a little bit more like a timeshare where they can pick a week or two during the summer and they have their exclusive use of the cabin during that time. And of course, I've seen a little bit in between. Sometimes everybody just shows up at the big lake home and they just figure out the way to share it. So within that operating agreement, we can state who the owners are, and we can divide out the different aspects of ownership. So ownership is an equity interest, and owners or members of an LLC have financial rights. And bottom line, it means that they own a certain percentage of the assets that the LLC owns. So let's just say we have 4 siblings, and they each have an equity interest in 25% of the lake cabin. Use could be a different percentage. I've worked with a number of families where maybe we have 4 siblings, but one is out of the country and has no intention of using the property. But they want to stay in. They want to maintain their equity and financial interest, their investment in that property, but they have no intentions of using it. The operating agreement can accommodate that, and it could allocate costs to those who are using it, and the one who's not using it would not be allocated any costs. I have a situation where we have 3 siblings, and one wants to use it, and so he's given all of the use of the cabin. He controls the calendar, and he has first priority to use it. And the rest just say, well, maybe I'd like to be there a weekend or 2. So the equity is the same and is equal, but the use is different. And in that case as well, the allocation of the expenses is different as well. So those can be tailored to the family. We also can tailor the governance structure within the LLC. So how is this group going to make decisions? If we have a small group, we typically have all of the members involved in making the decisions. But as the group grows, if we're going from the second generation to the 3rd or the 4th, now we have a large number of people involved, and this can happen over time. Then we typically would elect a board of governors, as we call it, but a smaller group of people who would make the decisions on how to manage the LLC. So again, we're kind of getting back to that democratic structure where all of the members have a say, but they might take turns on a rotating basis on taking care of the management of the LLC. Within that, it's good for a group to decide, okay, well, if we have some officers, if we have a general manager, if we have this board, what decisions are they, and how much money are they able to spend without going back to the group? So we can sort of tier those decision makings based on the cost. So we'll often see, okay, the general manager, if there's $1,000 expense, they can just take care of that without going back to the group. If it's 1,000 to 10,000, that needs to be a board decision. If it's over 10,000, then it needs to be taken back to the whole group of members to make that decision. So it's a good way to place some controls within the operating agreement. And as I mentioned, we can spread out some of the management responsibilities. Who's the one who takes care of the regular day-to-day things, who's the one who takes care of the checking account and pays the bills. Those things can be spread among the members, and then people can take turns. Some of the other important parts of that operating agreement would be, as I mentioned, accommodating change. Let's say someone no longer wants to be a part of the family cabin. This just isn't working out for them, it doesn't fit with their current life, and they would like to take their money out of it and get bought out, essentially. So the operating agreement can allow one of the members to trigger a buyout and then set forth the terms of that buyout and how that would be done, and kind of give everyone some comfort about that process, and also some protections for the remaining members, that they wouldn't be forced to maybe come out with the full purchase price right away. The operating agreement can set out that it's paid over a term of years, for example. Operating agreements should address, what percentage of the members need to vote for an outright sale of the property. That's typically unanimous. We can build in some conflict resolution, maybe how do we deal with impasse? And also in addition to the buyout, we would have, okay, how can this get passed on to the next generation? So often what you'll see in an operating agreement is that descendants of some grandparents are allowed to be the member owners of the particular Lake Cabin LLC, but no one else is allowed to be. And so within that, the buy-sell terms, as we call them in kind of the business world, they might say that someone can gift their membership interest to their kids, either while they're alive or after death. Or, if they don't have kids, then they can gift them to other members or to nieces and nephews and that kind of thing. But there are ways that we can keep that cabin within the family, keep the number of people limited, and keep spouses out of that. So we don't have to worry about that rotten son-in-law. But I've also seen spouses accommodated so that they're allowed to use the cabin during their lifetime, but they don't end up with an ownership interest. So again, I could go on and on, but what I really like about the Family Cabin LLC as an entity, as a choice for this long-term ownership by a group of people, is that it can be tailored for the group, and the group can be creative about that and really put something in place that is a good fit for them and works for them. And I think that that's putting them on the road to success. So I've gone through a few of my real life examples already. I've worked with that successful group of 9 where they treated it a little bit more like a timeshare. Recently, I've worked with some bigger groups, and they have larger properties where they all stay together. And I think they really enjoy coming together as a family every summer at that property. In 1 week, I talked to like all 3 types, including a group that was heading to court because they weren't able to put any kind of agreement together, and they were already fighting. And also groups that are just starting, like my phone calls this week. So I like to close out with this picture, because that would be my family cabin that I will be owning with my brother and my sister. And so these issues are very real for me, and I'm sure they're thrilled to have that resident expert in the Family Cabin LLC. But anyway, we've started our conversations on how that might work, and that's the best place to start. So start having that discussion while the current generation is still alive and we have that next generation involved. What is that commitment? What is that desire to own the property together? And then think about the Family Cabin LLC and whether that's a good option. What I also like is that as far as the tax issues and the timing of the transfer of the property, the LLC can accommodate a number of different scenarios. So we can make a good tax decision and also a good long-term decision for the family to set things up so that they can enjoy that cabin together, protect the legacy, and carry on.
Thank you, Andy and Laura, for taking the time to share your expertise on the topic of property succession. I always learn a ton when I hear Andy and Laura speak to this topic, and I hope you did as well. So this is Allie again to bring us back to our land protection focus. and how one method in particular, conservation easements, fits well with many of the considerations that Andy and Laura just discussed. So as a reminder, Northern Waters Land Trust has 3 methods for achieving our mission of preserving land to protect water. Land sales or donations are where we can acquire a property that a landowner is looking to sell or donate. Conservation easements, which we'll dive into deeper shortly, and then community outreach as well. A conservation easement is a voluntary legal agreement between a landowner and a qualifying conservation organization that perpetually limits uses of the land to protect its conservation value. And for the purposes of this definition, perpetuity means a really, really, really long time. One way that we see conservation easements utilized effectively when it comes to lakeshore properties is, say that, for example, you have a family cabin that's main footprint and kind of usage area includes 100 feet of shoreline, but you have additional acreage that's undeveloped. In this case, we recommend placing the easements on the portion of the property that's undeveloped and is lower use, and then maintaining that 100 feet near the cabin as a higher use area. This allows for continued recreational enjoyment of the property by the owners while ensuring that no development takes place on the remaining acreage. The process of placing a conservation easement on a piece of land entails lots of dialogue between the land trust and the landowner. Conservation easements can be customized to the needs and vision of the property owner, as long as appropriate use restrictions are in place to protect the land's conservation value. The land trust conducts due diligence regarding program eligibility, appraisals, title work, etc. The landowner and the land trust work together to draft the specific easement language, and once signed, the easement attaches to the deed of the property. The land trust acts as a partner to ensure your land is protected according to your wishes, now and in perpetuity. So there are 3 different ways to approach a conservation easement. The value of a conservation easement can be donated to a land trust, which can be written off as a charitable income tax deduction. Land trusts may compensate a landowner for placing a conservation easement on their land, which is a sell category, or there can be a mix of both of these things. So a landowner can receive partial compensation and gift the remaining portion of the easement, with that benefit once again being a charitable income tax deduction. A conservation easement must have a conservation purpose. So easements must have one of these 4 purposes to qualify for that income tax deduction. They must preserve the land for either public recreation or education, ecosystem protection, open space preservation, or historic preservation. Most undeveloped lakeshore parcels qualify for both those second and third purposes, which were ecosystem protection and open space preservation. And then for our program, the property must be at least 20 acres in size, with larger properties being higher priority due to their higher conservation value.
The outdoors defines Minnesota. It can inspire us, rejuvenate us, and connect us.
In the early evening, Grandpa and I would sit out on a bench. He would start pointing out the birds, and then he'd talk about how much they ate, what they ate. That was one of the fun memories that it carried through the rest of my life with birds. And that's what I ended up doing, is working with birds my whole career.
And that is the power that the outdoors can have on us. So when Jane and Polly inherited their grandparents' land, they had some decisions to make.
We were watching around here as all of the development happened on the different lakes in the area, and we thought, well, Grandpa and Grandma, that wasn't what they liked. So we wanted to find a way that we could do something to protect the land.
And because they're not making new land, the decisions we make today will be Minnesota tomorrow.
Over 70% of the land in Minnesota is privately held land. So in order to protect the land, protect the water, we need to work with private landowners to be good stewards, especially around these priority lakes in northern Minnesota.
Whether you are a landowner or someone who wants to protect the natural places of Minnesota, support for the Minnesota Land Trust helps us all. For Jane and Polly, they worked with the Minnesota Land Trust to put their grandparents' land into a conservation easement.
After we have a conservation easement set, it doesn't stop us from being able to hike in the woods, going fishing, or bird watching, or hunting, or any of those activities. We get to do all of that and still be able to leave the land in a conservation state.
The delight of knowing that it's now protected, it makes you tingle, kind of all over, because it's safety for everything around us.
Protecting cold water lakes is critical to protecting some of Minnesotans' icons. The loon, the walleye, these depend on cold water lakes where cisco fish, which are a small bait fish that they feed on, can survive. In the face of climate change and development pressure, these lakes stand the risk to no longer being able to support these fish populations.
It's never too late to protect and restore the places you love. Leaving a legacy with the help of the Minnesota Land Trust is leaving a legacy for wildlife, your family, and your community.
Through our program, we can pay landowners to protect the land, and the whole process is free of cost thanks to the outdoor heritage funding that we have available by the state of Minnesota. Please contact the Minnesota Land Trust for more information. We look forward to working with you to protect our lands and waters for generations to enjoy.
We accept applications year-round for our grant-funded land protection programs, including conservation easements. This is a competitive process, so applying does not guarantee your selection, but if you're interested in learning more about conservation easements and how they might fit within your property succession planning, please feel free to visit our website to fill out an application. When thinking about supporting conservation, it's important to know there are ways to give that can also provide significant tax advantages. Here are 3 of the most tax-savvy methods to consider. First, we have qualified charitable distributions, or QCDs. If you're 70 and a half or older, you can give directly from your IRA to a nonprofit like ours. This counts towards your required minimum distribution and is not included in your taxable income, which can lower your overall tax bill. Secondly, donor-advised funds, or DAFs, allow you to make a charitable contribution, receive an immediate tax deduction, and recommend grants to nonprofits like ours over time. It's a flexible and strategic way to manage your giving. Finally, gifts of appreciated stock. By donating stock that has increased in value, you avoid paying capital gains and can deduct the full fair market value of the gift. These methods not only support land conservation, but can also help you reduce your tax burden. We always recommend consulting with your financial advisor to determine what's best for your personal situation. Like many land trusts, we are open to accepting property donations on a case-by-case basis. We'd be happy to set up a meeting to chat further if this seems like a possible fit for you. Thank you again for tuning into this webinar for succession planning on your valuable lake property. We hope you found it informative. Thanks again to our speakers, Andy and Laura, whose contact information is here on the slide. I've listed mine as well as our executive director, Annie's. If you have any questions about the content from the webinar or Northern Waters Land Trust. Thanks so much.